Good morning. On behalf of the Indian Business and Professional Council, Dubai, I welcome you all for this breakfast session, specifically on the topic wills for expats in the UAE. It's good to see so many people who know. It's a unusual topic, insurance and wills, but people are interested to listen about it. And we do have a feedback in the end of the session today. To straight away start with the session, may I request our President, Nimish Makwana, to please come up on stage for the opening remarks.
Good morning, dear members, seniors and friends. Rightly said by CB, it's really lovely to see such a large gathering early morning, and this shows that topic is so relevant, and you all must have many queries back of your mind, and I'm sure we have three expert speakers, Mr. Vivek Agarwala, partner and head of India practice, Mohammad Ali Al-Hamadi Law Firm, Mr. Mohammad Maria, managing partner, Just Wills, and Mr. Deepak Gurnani, estate planner and partner, Just Legal Consultancy. We have kept the structure of the event in such a way so that at least 30 to 35 minutes we will have for Q&A, and keep ready with all your questions and take the benefit of our expert speakers and utilize this forum to clarify all your doubts. As you know that any corporate require the succession planning, it is very important for individual also. They need to plan to protect the interests of family, and that is how this session has been kept. And I am sure that at the end of the session, all your queries will be answered, and if it is not answered, we'll ask speakers to be here and please answer the query so that while you go, you will go with full satisfaction. Before I hand over to Vivek Agarwala for his presentation, I would like to share that you all must be aware that circular has been released for event on April 29, which is going to be with spouse, remembrance and tribute on centenary anniversary of Jallianwala Bagh massacre, and conversation on Khuni Vaisakhi by His Excellency Navdeep Suri, Honorable Ambassador of India to the UAE. I had the opportunity to participate at book launch of Khuni Vaisakhi by His Excellency Navdeep Suri, Honorable Ambassador of India to the UAE. And believe you me, the conversation will really raise goosebumps all over. I request each one of you, make sure that you all attend along with spouse, and it is going to be really one of the historic event for IBPC. So now I'll request Mr. Vivek Agarwala to come and start the proceeding and give the presentation, and then take forward the rest of the proceedings. Thank you very much.
Good morning, everyone. Thanks, Nimishji, for the introduction. Warm welcome to everyone. This is may not be the most interesting topic to discuss early in the morning, but thanks a lot for good turnout. I hope that at the end of 1 hour, most of your queries are clear. You may not be inspired to make a will, but you should know what is the regime, what are the options for will in UAE. It's a bit tricky area. There are a lot of misnomers about it, so we'll try to demystify that in the next 1 hour, and I promise I'll make it very clear and precise with not too many legal nuances so that it's very clear. And as the event is structured, we have kept a lot of time for Q&A, and other experts will join, so we'll try to answer your questions as much as possible. So I look forward to your participation, and with that I'll start. First slide I've kept for why we may not have wills. So I guess most of the people present here, they may not have wills already in place, and that is why you are here. So I just thought of putting down few points why we generally do not have wills. First is we will manage attitude. That's typical of we Indians. We think it's not very high on priority. We can do without it. nothing will happen to me. And we all know how uncertain life is, but we do think nothing will happen to me and we'll manage if something happens. But unfortunately, in this case, you cannot manage because you won't be there. This is a situation. Will is a document which comes into force only when one is no more. At any time during the life of a person, a will can be amended, replaced, but it comes into effect only when it is one is no more. So it's very important to have it placed before it's too late. Other reason I thought is UAE temporary home. Most of us, we come here, we think we'll be here for a couple of years, then go back. So it may not be worth making a will here, we'll have it back in India. But most of us, we know we love this place, we grow here, and we tend to be here for longer than what we expected. Another reason back home, interstate succession is generally accepted. So I'll show in further slides how the succession happens if one dies without a will under, say, Hindu law, which is more or less accepted, unlike Sharia law. So, I mean, in India, even if one doesn't have a will, that is okay, because you might be okay with the succession which happens even without a will. Hassles involved, of course, it requires time, effort, money to make a will, and sometimes this is low on priority, and you don't think it is that necessary. Last is cost. I mean, I meet a lot of clients for whom cost is a very important consideration, and they don't go for will because typically the question is, what is the price for DIFC and other regimes? It turns out to be, they think it's a bit high for a thing which may not be that important. So that's another reason why quite a few of us do not have wills. I'll go to the next slide, why we should have will. Now, in my view, this is a key element of financial planning. So there are a lot of elements of financial planning, like you want to have insurance in place, you want to have all the deposits and on all planning, but will is also a very important part of financing planning. Then to meet financial needs of the people you love and care about and causes you support. Causes you support, by this I mean you could have the assets given away for the purposes of charity as well in a will. And of course you want to give away whom you love and care about the way you want, in the ratio you want. And many disputes can be resolved by making a will upon one's demise. Here I would like to give the example of Mr. Vijay Pat Singhania of Raymond's. You would all know the story. So what he did is, unlike making a will, he gave away his assets to his son during his lifetime, which is sort of substitute for the will. If you make a will for your assets to go to your son, that takes place upon your demise. But he gave away this during his lifetime, and then they were involved in a bitter litigation which is still going on, and he got sort of a raw deal from his son. So this is a very accurate example to say, like, if he had done a will, then assets will continue to be with him during his lifetime, and his son gets assets only upon his demise. And to avoid applicability of foreign law. So I'll come in the further slides why ordinarily Sharia law will apply here, and you want to make a will to ensure that Sharia law does not apply. I mean, as a lawyer, I can tell 100% it cannot be confirmed, it will not apply in this part of the world. But wills takes care of this, and to a large extent, it could be ensured that the distribution will happen as per your wishes, and Sharia law will not apply if a will is properly made and registered. Now, this is an interesting slide. I wanted to show how distribution happens if one dies without a will, under Sharia law and under, say, Hindu law. So if you see in this slide, this is just an illustration. So if the husband is no more and he leaves behind his wife, son and daughter, then under Hindu law, all three will get 1/3. But under Sharia law, if you say it's a bit complicated, wife gets 12.5%, son gets double of daughter, and this is how it happens, and it could be much more complicated depending upon various circumstances. But this is a very illustrative example to show it's quite different under Sharia law and Hindu law. Another example, husband dies leaving behind wife, father, mother, daughter, and son. So in this case, under Hindu law, wife gets 1/4, and so does mother, daughter, and son. Father doesn't get anything, but if you see under Sharia law, it's again quite different. Son always gets double of daughter. So this may not be what one likes, and that is why one might like to make a will. I just thought of giving a typical example in here what happens, say, so Indian Hindu dies here, leaving behind father, mother, wife, and one son. He got an apartment, a bank account, a car. So this is a typical example. I face such situation quite often. You don't know what happens when one is no more. And in this situation, when there is no will, so typically how it works is, we have heard the stories, accounts get frozen. So that's something immediately happens, and then there is a liquidity issue. So, and this happens both in the case of single account or joint account. If one of them passes away, the account is frozen, and it takes time. I mean, it's a matter of time, you'll get your money back, but it takes time, it requires a court order, and that court order I'll discuss subsequently. It becomes easier if there is a will in place, otherwise it is under Sharia law. And transfer or renewal of assets. So if one passes away, the home is his name, then his family continues to be at home. I mean, it's not that somebody comes and takes possession of home, but in case he wants to sell, or say there is a car and there is a renewal of that car pending next year, there could be difficulty if the owner of that car is no more. So these things needs to be taken care of, and a will helps there. Before moving to wills in India, I just thought I'll have a quick slide on how it works in India. So this is a matter of personal law. Uniform Civil Code, this is under consideration in India. I think it will take a long way. So till that happens, it's a matter of personal law. So for Hindus, Muslim, Christian, it happens as per their religious laws, and that's how succession happens. Registration not compulsory. So a lot of people have misnomer on this. It is compulsory. So at a matter of law, it is not compulsory, but it is highly, highly recommended to have a will properly registered in India. And as mentioned earlier, for Indian assets, you can have that done here at Indian Consulate. That is as good as, for all practical purposes, having registered that in India. And that's quite useful. So just to clarify, it's not compulsory, but it is recommended, because otherwise you have to go through the additional step of proving its genuinity and to say that this was the last will. So registration practically takes care of a lot of things. And of course it can be amended or revoked anytime. So once you make a will, it's not cast in stone. During lifetime it could be changed anytime, and this goes both for UAE and India. Now, wills in UAE. So I thought if you look historically, this country, it's always linked to development of property law. So earlier, foreigners cannot own land here. Then there were leasehold rights. Then there were freehold rights. So you see gradually the areas are increasing where you can own land or you can own property. But once you can own, one of the key questions is that you want to ensure that it continues to be with your family and heirs once you are no more. So that is why the wills comes in gradually. All the emirates are coming out with jurisdictions and regime in place to ensure that you can make proper will and register, and that definitely pushes investment in the country and the real estate market. So it's linked to expat ownership right. And then I just thought I'll show an extract from Constitution of UAE. I mean, we all hear a lot about Constitution of India. But let's see this Article 7 of Constitution of the UAE. Islam is the official religion of the Federation, and Muslim Sharia is the main source of its legislation. This is an article in the Constitution of UAE. It's the it's the main source of legislation. It's not the only source of legislation, so we all know this is a year of tolerance. There are a lot of things which are accepted here, which are beyond Sharia. For example, interest, that's quite accepted, it's legal. Same like wills, which are beyond Sharia, they are accepted, and likewise there are a lot of things which are beyond Sharia, which are accepted here, but we have to bear in mind under Constitution, Sharia is the main law of the source of legislation. Couple of other provisions from laws. Under Civil Code, there is a provision which says inheritance shall be governed by the law of the deceased at the time of his death. So basically this clause means, in my case, when I'm no more, my law of my land, which is Hindu law in my case, should apply. But practically speaking, it doesn't happen that way. Most of the cases when it goes to the court, typically Sharia law will apply. Court will be tempted to apply Sharia law. So that's the practical aspect. And we all living here, we know that that's more important, how it actually applies in the court. There is another law of personal status here, which says you are allowed to make a will under your own law. But again, practically Sharia law applies, and that's important. Now I'll come to the regime of wills in UAE. So I'll talk about three main regimes, which is Dubai onshore, DIFC, and Abu Dhabi. This is the first one, which is actually the latest one, which is Dubai onshore. This was under a new law number 15 of 2017, and this was sort of maybe to compete with the regime in DIFC, and they wanted more business onshore. So I'll not go into too much details, just the key features only for non-Muslims. So one has never been Muslim, there is a declaration required in the will. That's an important clause. Only for Dubai assets. So I know practically there are a lot of wills registered in Dubai with assets throughout UAE. But this law definitely has a clause which says this is only for assets in Dubai. Wills under this law can be notarized. The law talks about a registry. This is very important. The law talks about that there will be a registry for wills made under this law, but this is not yet active. We checked as late as yesterday, and we were told that the registry is not yet active. We do not know a timeline, but we are tracking this. Till now, till that becomes active, there is an option to have your will notarized, and the authorities tell us that that is as good as having it registered. So once the registry becomes active, you could get it registered, but otherwise, if one passes away before that, notarized will be deemed as if it is as good as registered. I am not personally aware of any case how it has been actually implemented, but this is how the authorities have told us. The implementation regulations, they are yet to be issued, and I think this will also talk about when the registry would be active. These are again a couple of other provisions from the Dubai will law. He must be above 21, he or she. The bequest shall be owned by the will maker. Of course, you could only make will for something which you own. And termination of the will, this could be cancelled or amended any time at the registry. This goes also for the Indian will. Multiple wills, if one makes multiple wills, then one which is registered at later set time will be effective. Inconsistency, Article 35, in my view, this is a very important provision of this law, which says any contradictory provision in any other law is abrogated. So by this, perhaps it could mean that the provision in the other law which we just discussed, which showed that Sharia law will apply in case of real estate, perhaps that is overridden by this, and hopefully if a will is made under this law, then this law will apply and the assets will be distributed as given in the will. A couple of other provisions. It says executor, he's the person who will take care of execution of the will and implement it as provisions. It said he should have no interest in the bequest. So this is again tricky. A lot of times we see that the executor and the beneficiary are the same person. But under Dubai law, there is an express provision which says that he should not have any interest. But it also says that if he has interest, that doesn't make the will unenforceable. So I mean, this could still work if the same person is appointed. Maybe court will appoint somebody else as the executor to avoid any conflict. Order of payment, execution and expenses are paid first. Then if there is any outstanding out of the state of the deceased, then that is paid, and then whatever is left go to the beneficiaries as per what is stated in the will. Enforcement of a will, it is by order of the court if it is registered, and if it is not registered, then it's lawsuit. So basically it's a more detailed process if there is no will, and if there is will, the process could be a lot more fast in a court of law. Quickly coming to the DIFC will, which started earlier in 2015, this is active and functional. There is a registry you could register. I would encourage everybody to visit its website. It's quite active. There is a lot of information there. They also have a template of the will there. And a lot of probate has actually happened. If you go to their website, the lot of actual enforcement of will registered under DIFC has already happened. So we have a precedent for that. That gives a lot of confidence that it is working. There is a agreement between DIFC court and Dubai court that once there is an order from DIFC court, that would be enforced in Dubai court. So this is quite functional. It is in English. It gives a lot of confidence, quite precise document. Only for non-Muslims again, for properties in Dubai and Ras Al Khaimah. So at the moment, DIFC wills is only for Dubai and Ras Al Khaimah. But I can share with you, I am a part of DIFC draftsman, registered draftsman, and the last meeting, they were very clear that they are going to extend it for whole of UAE. So this is something under very active consideration of DIFC that in some time this will might be open for assets all over UAE. And then I think that makes it very attractive, even if the cost is a bit higher, which we'll discuss in further slides. So DIFC has a regime of different kind of wills where the costs are also different. Very briefly, I'll touch upon that. Full will, where you could talk about all the assets. Property will is about real assets. Financial assets will, here you could include bank accounts and any other investments. Free zone company will, quite interesting. So if you have shares in a company at the moment in Dubai or Ras Al Khaimah, free zone or onshore, you could have a will and that could be registered. And then there is guardianship will, which is for minor children. These are the types of will in DIFC. Again, I think they are considering, and this list might be narrowed down because typically, quite often people will go for, say, full will or property will, guardianship will and all. Practically, it doesn't work because if you have minor children, then you also have bank accounts, so you won't have only guardianship will. So this is also under active consideration of DIFC. It might be reduced. Abu Dhabi registry, this is quite interesting, I think, mainly for the fee. And a lot of people are going for this. Started recently, and it covers all Emirates. So I had a call with that registry, and they clearly said you could have assets throughout UAE in a single will. The process is quite sophisticated and not very complicated. It doesn't require too much of hassles. And a lot of processes is online, and the fee is only 950 dirhams. It's quite active, and I'm aware that a lot of wills have been registered there. A lot of Indians have registered their wills with Abu Dhabi registry. Now, this is just a comparison of three wills, which you will find interesting. DIFC, Dubai, and Abu Dhabi. In terms of fee, DIFC full will, it's 10,000 dirham. Dubai, its registry is not yet active. You could have it notarized. Cost is around 2,300. And Abu Dhabi, it's under 1,000 dirhams. In terms of language, which is important because you have to be, in case there is a conflict, Arabic will apply. So in DIFC, it is in English, and in Dubai and Abu Dhabi, it is bilingual or Arabic. So, and of course, full will is 10,000. For other type of wills, it is lesser. And you would be aware there is a concept of mirror will, which husband and wife makes will making beneficiary each other, there typically the fee for DIFC turns out to be 15,000 for full will. So for single person it is 10,000 and for mirror will it is 15,000. I think you will have queries on this and we'll discuss during Q&A. So this is just a quick checklist about if you practically go for making a will, what are the details required, what you should have ready with you before meeting an expert, details of the assets, real estate, shares and investments, bank account, any other account that you would have, supporting documents for the ownership in case you want to specify the assets in the will, which is ordinarily not necessary. You could specify or you could say all assets, potential beneficiaries, potential executor, preferably up to 3 levels because if one is no more before your death, you want to have a substitute in place. Passport copy and Emirates ID of the stakeholders, 2 witnesses. So typically these are the requirements, not very complicated, but it makes sense to have all this in place before you meet an expert. You can save a lot of time and efforts. I'll conclude with this final slide. So basically, will it gives you a high degree of certainty in terms of how it will happen, the assets will be allocated once you're no more, because otherwise Sharia law might apply and you might be in a realm of quite a few unknown things. So this makes a lot of things certain and you know how it will be done to a pretty high extent. Alternatives to will, so there are a lot of things one could do as part of their financial planning. For example, power of attorney. You could have a power of attorney in favor of somebody to deal with your assets, but please remember, power of attorney becomes ineffective upon one's death. So there were a couple of very interesting cases where one made a power of attorney and he was in a position, he had cancer or he was in a position where he couldn't do anything. He was sort of mentally dead, but he was not dead. And that time, technically, power of attorney can work. So for such quite rare instances, it turns out to be very effective because will only come into place once a person is no more. So this is another alternative. It does help to have a power of attorney. It is also advisable to have accounts preferably in single person and not in joint name, and to have assets in different buckets and not in one place so that one is not shocked. Recommendations, I had a slide which I have actually removed because I thought we'll discuss it in more details and we'll also have views of other experts. But in my view, if the assets are in Dubai and if it is substantial assets, in my view, definitely DIFC will makes a lot of sense. The fee might be high, but I think it has to be seen in proportion to the value of the assets. And it gives a high degree of certainty. There are precedent, it makes sense. The second option would be Dubai will. If the assets are throughout UAE, then it makes sense to have a Abu Dhabi will. And that's how it would work. So just to conclude, wills is important and it is recommended to have it. And it makes a lot of things quite clear, and sometimes later on you might feel that this could have been done, it was quite easy, but that might be too late. So it is highly recommended. Thank you.
Good morning, everyone. Thank you for this opportunity to talk about this very interesting topic. I mean, we all know how important it is and how wise it is. Now, Mr. Vivek has pretty much covered everything, like what are the options here. So in order to simplify, what I feel is that the objective is to achieve the distribution of your wealth here in the UAE, because law of the land applies. So we have to talk about what laws applies in the UAE. So the objective is to achieve distribution of your assets in the way you want. Now, I will compare this as if you have to go from destination A to B. So let's say you're traveling from Dubai to Mumbai. So you have an option to go in first class, and you have an option to go in economy. But the objective will be achieved in both. Similarly, if your assets are, let's say, only in Dubai, so you have an option to do DIFC will, which is more convenient. There is no communication gap for the family because it's an English code. The family can book an appointment themselves, visit them, and do it themselves, execute the will. On the other hand, Abu Dhabi is an alternate option now, since last year, wherein the objective will be achieved. You will reach destination, B, from A to B. But there might be a little bit of challenges like communication gap, but you can always hire an expert. But your assets will be transferred to the, as per the wishes of your will. So that can be taken care of, but obviously not as easy or convenient as we can do it in the DIFC. But cost can be a big factor. So that call we will leave it up to you. This is on a general basis. At the end, we have to sit down with individual and understand their requirement, because sometimes people not only travel in first class just for the luxury basis. Sometimes there is a need of it. Sometimes there is, due to health factor, due to different reasons. Similarly, you might need DIFC because, let's say, you can feel that there is some dispute might arise in the family. So to avoid, to cover all the corners, then we might recommend. So at the end, it is one-to-one. But generally talking about in registering your will with either DIFC or Abu Dhabi, your objective will be achieved. Because we are confident about Abu Dhabi as well. Not as much as the Dubai notary, but they are working, to improvise the Dubai code also. But I would keep that at the moment at number 3. So first priority, I would give DIFC, second to the Abu Dhabi code. But we are equally confident about that because that also covers the UAE assets, not only Dubai or Ras Al Khaimah, like the DIFC does. And Vivek also spoke about whether to have a will for your home country, especially about India, because laws are pretty much different and might be convenient or acceptable to you. But I would still recommend you should do the will for your home country as well to avoid any challenges, any claims, any contests. Because the law of India is quite simple, that it goes to your wife and children, not to your siblings, your parents. It might go in the default law. Again, the default law here is Sharia law, which might be in someone's favor, might not be. So with this planning, you can always decide your own wishes. You can choose where it should go. But the default law sometimes also can be someone's favor. So doing the will here is obviously, few years back we used to discuss whether we should do a will or not. Today we are discussing, we have identified that there is a need of will. But where we should register is a big question today. So we are not discussing anymore that whether we should do a will or not do a will. Because that was the discussion few years back, as far as my experience says. But today we have to discuss where we should register the will. So you have 2 options, according to me. I'll keep the Dubai notary at number 3, but that is also an option for everyone. So this is pretty much, just to introduce the system. I'll pass it on to Mr. Mohammed, and we can discuss in the Q&A session. Thank you.
Good morning, everyone. First of all, I just want to thank, obviously, everyone here for allowing me to become as a guest speaker to show you my experience on wills and everything else. I remember when I first came in this country in 2005. Coming from the UK, I was targeting the European expats. But when I came, I realized that it's the Indians that are controlling this part of the world. So before I knew it, my clientele changed from Europeans dealing with the expats from the subcontinent. That's where I had the pleasure of meeting people like Nimesh, who introduced me to all the associations here. Back in those days, when I was drafting wills, there was no court system. It was very upsetting. Everyone would say to me, when will a court system come? I had to tell them, I said, look, give the country some time. You have to be patient. In those days, I would draft the wills, you take it to the Indian consulate, have it attested there. Tell the truth, even I wasn't happy with that, but that was the only process. Dubai courts opened their doors back in 2012 for non-Muslim expats to register their wills. So I was telling everyone to go register the wills in Dubai courts. The fees those days was about think 70 dirhams, 80 dirhams.
Yeah, 120.
120.
80 for the power of attorney.
Yeah, power of attorney was 80 and the will was about 80 dirhams. Anyway, it was very cheap. Come 1st of April, of all the days in the year, 2014, from 80 dirhams, the fees went up to 2,200 dirhams. I thought, wow, a lot of people were upset. Some people were angry with me that I should know court fees are going up. And I said, how would I know? They just decide the fees are going to be this much. It becomes law, take it or leave it. It's like the land department fees. It was 2%, then they increase it to 4%. What can you do? You get upset, bite your teeth, or bite your tongue, sorry, and then move on. But you had to pay the 4%. DIFC came out in around about 2015. To tell you the truth, I was still with the fees, the fee hike from 80 dirham to 2,200. I couldn't get over it. So when DIFC came out, they said we're charging 10,000 dirhams to register a will. And I said to them, look, 2,200, 10,000, what's so special about your system? They said we are allowing the will to be in English. You're dealing with Europeans. You can register the will here, but this is our fees. To me, I looked at DIFC court. I mean, I tell you the truth, everyone. If I had the choice of having the office in DIFC, I'll move in straight away. But unfortunately, the price there is too high. So when I looked at their system, the fact where they are, I knew they had to charge this much money to justify their existence there. But that's a different matter. But when I looked at their system, they told me that time we're only covering assets in Dubai. So I said, wait a minute, what about if somebody has a branch license in Sharjah? Or the banking with Abu Dhabi Commercial Bank, which I do. And I've been banking with them for more than 10 years. They said, we are only covering assets in Dubai. Afterwards, they added Ras Al Khaimah to their list. So you're paying 10,000 dirham for 2 Emirates. Dubai court, even though Mr. Vivek said it's Dubai based, but I'm sorry, I'd like to disagree because I've executed wills in Dubai court and I've covered Sharjah, Ras Al Khaimah, even Abu Dhabi. So I can do it from the Dubai court. The issue is Dubai court will send an order to, for example, in one case we sent the court order to Ras Al Khaimah Economic Department, and Ras Al Khaimah Economic Department told us, go back to Ras Al Khaimah court and get them to put the same court order on their lettered-headed paper. We went and did it. The job was done. So with Dubai court, you can cover the UAE. DIFC's 2 Emirates. Abu Dhabi court, who just launched about a year and a half ago, they're also doing the UAE. Now, I just want to tell you something about Abu Dhabi courts. Many people may not know this. ADGM, which is Abu Dhabi Global Markets, which is the DIFC equivalent of Abu Dhabi, contacted us and said, we want to have a will system. I went to see ADGM and I told them, if you want a will system similar to DIFC, what you charge is up to you. They're charging 10,000, you want to do 5,000, 10,000, up to you. But don't make the same mistake DIFC has done by having coverage for 1 or 2 Emirates. The UAE consists of 7 Emirates. Make sure you have a system for 7 Emirates. Because if you don't mind me saying, ladies and gentlemen, when we are dealing with a death case, nobody can guarantee where the money is. I think I can say this safely for everyone. You could be in Dubai today, tomorrow in Abu Dhabi. You might have a company in Dubai, you can have a branch license in Sharjah. So when you look at the UAE, you need to look at the UAE as 7 Emirates. The best example I can give is if you have a property in Mumbai and you have a property in Delhi, are you going to make a will in Delhi and one in Mumbai, or are you going to make a will for the Republic of India? You make a will for the Republic of India. You can't go around making wills for individual states. Doesn't make sense. So Abu Dhabi Global Markets came to us wanting a system. And I told them, don't make the same mistake as DIFC. ADGM went back to Abu Dhabi court and said, we want you to give us the authority that we can register the wills for the UAE. What I'm telling you is very bizarre, very strange. But Abu Dhabi court said, no, we're not going to give you the authority to have a system to cover assets in the UAE. Then before I knew it, Abu Dhabi courts brought a system out to register wills. So it was just an idea they took and said, we can do it. Now, I've been dealing with Abu Dhabi court since its inception, and I can tell you we're very hands-on this matter. They have now got an online system that when a person passes away, when you're dealing with a death case, the court orders are going to be sent within 2 weeks of the deceased, and they will have everything online, which means they have a much more swifter system. The fees is very attractive at $950. But the point I'm trying to make, ladies and gentlemen, is that when I was drafting wills since 2005, there was no court. Now we have 3 courts. So I am of the opinion more of Abu Dhabi court, because nowadays I think we all can agree everyone is very cost conscious when it comes to these matters. I mean, when Mr. Vivek was saying about people not having wills in their home country because of cost reasons, I can tell you here it's the same. People think about cost all the time. So when we're talking to the public about wills, we say, look, you can go to Dubai court, this is the fees, this is the coverage. DIFC court, these are the fees, this is the coverage. And Abu Dhabi court, these are the fees, this is the coverage. So I like to say there's 1 or 3 courts you can register the wills. But if you don't mind me saying, dealing with the death case, I tell you where the problems are. And please, I don't want to offend anyone here. The biggest problems are as follows. Number 1, husband, don't tell the wife where the money is. This is so common. I deal with so many cases, the wife is clueless. She doesn't even know in which bank account the money is sitting in. So when I'm drafting a will, I will never make a list of, I'll never include the list of assets in the will. It will keep changing. That's why it's very important you have the housekeeping tips in order I'm going to tell you. Number 1, keep a list of assets, write everything down. For the women, always have separate visas, have separate bank accounts. Keep life insurance. If you have children, young minor children, it's very important you open trust accounts in your home country. And keep life insurance. In this country, everything has got to be paid. I had a case where a husband died. We were dealing with the RTA. The court order went out to the RTA to transfer the car to the wife. The wife went there for the transfer. And the RTA said there is over 5,000 dirhams of fines. And she said, well, her husband is dead. Why should I pay the fines? The RTA said, sorry, fines got to be paid. We cannot allow the transfer. She had to borrow money to pay for the fines. And can you believe her luck? Because the Emirates ID card was cancelled, we couldn't do the transfer in her name. She had to sell the car. These are the problems. Problems is where you have loans with the banks and there's no life insurance. Banks want their money. There are problems where people assume they have life insurance with a mortgage. Assume, but there's no life insurance. There are cases where people tell me we've completed a beneficiary form to cover end of service benefits. There is no beneficiary form. But to me, I tell you the biggest problem, and I'm not going to limit this to the UAE, this is a global problem, no one knows where the money is. That's why banks are sitting on millions, if not billions, of dollars, rupees, whatever currency you may think of. No one's there to claim the money. This is where the problems are. And I just want to give you one case example I dealt with before I finish the talk. I had a case where in Emirates MBD Bank, they contacted me and told me that one of our employees died in 2009, and up till today, nobody has come to claim the money. Now, you may not know this, but in 10 years, when you don't claim the money, the banks here have to give the money to the Awqaf. In the UK, if you do not make a will, you pay 40% tax to the government. And if you don't claim the money in 5 years, it goes back to the government. Here, the notion is 10 years, the money goes to the Awqaf. Now, this person died in 2009. 2015, the bank contacted me and said, we've got the money here, we don't want it, but we don't know what to do with it. They gave me one death certificate, one passport copy, and a telephone number. Said, can you please track down the legal heirs? I cannot tell you how we managed to locate the mother in India, in Kerala to be exact. And in 2017, late, we transferred 900 lakh rupiah to her account. And she told me that we never even knew our son had this much money in the account. He died, he was only 29 years of age, no wife, no children. It was very tragic for the mother. These are the problems. To me, registering the will is up to you which court you go to. But if you're not sharing the information where the money is, that's the biggest problem. And like I said, it's not a local, it's a global problem. You need to make a list of assets. You need to share the information. All your internet passwords, your mobile banking, any important documents, you need to share it. You need to share it with your children if need to be. Because if both husband and wife pass away, even the children need to know where the money is. But when I'm dealing with a death case, a wife come and tell me, I don't know where the money is. She might know one bank account, but that's it. Even companies like National Bonds are telling me they're sitting on a lot of money, but there's no one's coming to claim it. Thank you very much, ladies and gentlemen.
Thank you all. Now we'll start with the Q&A. Can we?
Good morning, panel, and everybody, and to the newly elected president. Delighted to have a very thought-provoking topical subject. I have two questions. I'll be very quick. My first question is about the DIFC wills. Yes, it's obviously very straightforward, meant for the expat community, in English. Does it require an Arabic legal translation?
The official language of the DIFC court is English. Written, spoken, communication, everything is in English. The staff is English. For the first stage where you open the case, execute the will, obtain the grant of probate from the DIFC court, there is no Arabic required. On step 2, when the order is issued, which says that, okay, this is the asset, let's say it's property, the land department will be addressed. If it's a car, RTA will be addressed, and so on, so forth. Like banks, the bank's legal department will be addressed. Those order has to be in English or in Arabic, because those are the local department, which for official language is Arabic. But that is an administrative issue. And the order, once issued from the DIFC court, has to be further stamped and signed by the Dubai court, because the authorities here takes order only from one court, which is the main court, which is the Dubai court,
Exactly.
not from DIFC. But like I said, it's an administrative
Procedure.
issue.
So
procedure.
the translation can be done at any stage?
Yeah, first stage you
upon
don't need the
requirement.
translation.
You don't need it
Stage 2.
simultaneously with the same date to be sealed together or notarized together.
Not on stage 1, but like for example, if there is a death certificate issued by any other country, and in later stages they might need a translation for that, but DIFC will accept as it is.
Very good.
Local death certificate are issued in both language, and foreign death certificate can be translated. So,
In due course, all right. Can I have a quick other question?
please.
All right. That's perhaps for Mr. Mohammed or any of the other panelists. I have a scenario here. Let's say husband and wife, resident in the United Arab Emirates, have a property. The wife has not signed on the mortgage document, but the property is obviously either in the husband's name or it could be in joint name, without the spouse or the wife's, particularly the wife's signature on the mortgage agreement. Let's assume, yes, there is a life insurance, or another scenario without a life insurance. Hypothetically, upon the demise of the husband who has taken out a mortgage from the bank, has the property in his name, another simultaneous scenario where the property is joint, what happens to the mortgage amount? Who pays that? Does it mean by virtue of being married, the wife is liable? For example, the fines had to be paid. Is the wife liable to pay the mortgage?
Well, no other person is liable for someone else's debt, first of all. But the asset, the estate of the deceased is liable to pay any loans or liabilities in this country.
Of course.
So, if there is $500,000 of debt and $1 million of asset, it will be settled from the asset. If there is $500,000 of asset and $1 million of debt, the other $500,000 will not be recovered from the family members. They are not liable to pay anyone else's debt. But the asset, the estate of the person is liable to pay the debt of the deceased. And insurance nowadays covers the outstanding, the mortgages, you know. That is the reason we also recommend that one should have insurance to cover liabilities, because the whole point of freezing assets in this country is to secure the liabilities part, because 90% plus population here is from outside the UAE. We all are expats. So the government should obviously secure their own position first, which has consequences, but there are solutions to it.
Ram Tolani from Goodwill Insurance Brokers. All three panelists are widely experienced and very knowledgeable. Thus, I ask you a question on behalf of the entire community here, that we have been discussing only about UAE properties and India property. But most of us here have got multiple properties all over the world. How would that be covered with this kind of formula? Is there any formula, if somebody can share that? Appreciate it. Thank you.
The global will, sorry, please, Mohammed. The global will which we prepare, which is excluding UAE, which is registered in a home country consulate, can cover the rest of the world where common law exists, where wills are accepted. So the law of that land should not basically say that, okay, we don't accept the will, we will apply our own laws. If they accept the concept of will or the home country laws of that person, the person who has died, then the global will cover everything.
I beg to differ there. There are certain countries like Canada. For example, a will drawn up in this country is not in any shape or form enforceable in Canada. You have to have a separate resident will. For any property owned, bank accounts, businesses, etc. The same thing takes place in the United States of America.
Can I just...
So a global will does not necessarily mean that certain countries will accept what you have stated in your DIFC will or in your Abu Dhabi registered will. The country in which the assets are held at times require a separate will to be made in that country and registered.
You're 100% right.
With a solicitor or a lawyer.
You're 100% right. That is
There are
why...
no registration bodies where you need to actually go. It's the lawyer who keeps it in a safe deposit box.
You're 100% right. That is the reason I mentioned wherever the wills of the deceased home country laws or the wills are accepted, those places this global will work. It's not going to work in all the 200 countries. But at the end, when we sit down with the client, we understand where are their assets are, so we accordingly guide them.
Just to add to that, I mean, the idea is no two will should supersede each other's assets. It should not be any contradictory thing. So you cannot have one will in India, it says my assets all over the world, and then having a will here which says my assets in UAE. That's contradictory. So the will in India must say my assets in India or all over the world apart from UAE. Now to answer your questions, I mean, I don't think any of us are experts in laws of Canada here. So if you have assets in Canada, then technically you can have a will in India which includes your assets all over the world except UAE. But of course, if you have assets in Canada, it is advisable to take opinion from a lawyer in Canada. And if laws of Canada, which is specific laws of that country, requires a separate will for assets in that country, then you have to carve that out. Then your global will in India will say assets apart from UAE and Canada, and for that matter, any other country. But as a principle, it is not advisable to have assets for every single country, unless there is a requirement of that specific country to have separate will of that country.
What you also need to make note of is that there are a lot of Indians whose original nationality may have been Indian and may have taken overseas nationalities like United States, UK, or wherever, like our friend here, for example. In such cases, having a will done in India, as you just stated, is of no use, because you are no longer an Indian. You are a national of that overseas country whose nationality and citizenship you acquired. So you need to take into notice that country and not India.
Yeah, of course. In cases of wills, please.
We have just recently executed a global will in Jersey. I myself went November last year, executed. No, I mean, that's what I'm saying. You are taking an example of Canada.
I'm talking about the United States, Canada, and even the UK. And I'm sure he's an expert on UK since he's
Look, if I can explain one thing. when you're looking at laws of different countries of the world, there is a common law versus civil law. Okay? Now, many countries are under the common law, one will would suffice. But if you're looking at countries that operate under civil law, I agree you need a separate will. But also I'd like to add to say that when it comes to movable and immovable assets, there's also a different law for that. So going back to what you're saying, for assets, say in Canada, yes, it may be an idea, you speak to someone there. I would never touch the US, for example, because each state has a different tax law. Then you have a federal law. So on one hand, they say the United States of America, but then when you look at the tax laws, they're not united, I'm afraid. So any American clients, forget where they're originally from, I see you make your own will in the US and obviously speak to a tax lawyer in the state where you have the asset who can advise you better. Countries like the UK, yes, I agree, they have inheritance tax. So it's very important that you draft a will accordingly. But with Deepak saying about the global will, I think he's referring more to common law countries and especially movable assets like bank accounts. But one thing I also like to add, once a probate order is issued from the Dubai or the Abu Dhabi court and you have a global will, you can apply this to other countries, but it's recommended still that if you have an immovable asset, say in Canada, you definitely make a will there locally. And the Canadian consulate here are attesting wills. So if you have assets in Canada, you can make a will here, take it to the Canadian consulate, attest it, and it will cover you in Canada then. I hope that answers the question. The lady at the back who was asking the question about the mortgage, if I can just add one thing. If the title deed is in joint names, technically you both own 50% each of the property. The life insurance would always be in the husband's name unless you you told the bank, I want the life insurance in my name. So you need to be careful that if you have the life insurance in your husband's name, is it covering 50% of the mortgage or 100% of the mortgage? If it's covering 100%, the full mortgage will be cleared. But in my experience, it's always 50% because it's the property will be in two names then. So life insurance is very important, and if you don't mind me saying, you should look at insurance for both husband and wife. The concept here is the husband will die first, the mortgage is in his name, have the life insurance in his name. But I'm of a negative pessimist type person. I would say get yourself insured as well. So if you pass away, the life insurance is paid out and will clear the mortgage completely. If the property is in joint names, you own 50%, the husband owns 50%. Under the Sharia law, you'll take 1/8 of his 50%, so you will receive 62.5%. The fact you're married is irrelevant. I'm just telling you what the Sharia law states. If the husband wants to give you the full 50%, he needs to do it by will. Thank you.
With the permission of the House, can we extend the session for 10 more minutes? Yeah, thank you.
Niti, good morning. I will help you answer all those questions you have. As this gentleman rightly said, under the insurance policy, if both lives are insured, it becomes more easy for payouts. And again, in this part of the world, for my colleagues here, for any mortgage application, an insurance application is compulsory nowadays because it takes care of it. Coming to my question, thank you very much. Vivek, you spoke on the Sharia law, Hindu law. In this part of the world, again, in the UAE courts, the Sharia law supersedes any beneficiary form, even if it's an insurance form. And I'm 100% sure about it because I'm coming from that background. Wills came in this part of the world only in the year 2015. And as he knows, the challenges from 2005 to 15, people were struggling to make a will to get the claims payout. My question to you here is, now DIFC and the ADGM, people will definitely prefer Abu Dhabi because of the costs, it covers the UAE, all that is up to us. From 2015 to now, and as You know, in this part of the world, 60% of the population are more Indians, and they are more prone to all these things. There are a lot of, especially from the insurance world, I have seen a lot of conflicts and a lot of cases. What is your experience and what payouts have you done? How many payouts from 2015 to 9? Do you have any claim statistics to instill that confidence in us, for us to, yes, I need a will. It is a necessity, just like an insurance application today.
First of all, to talk about insurance case which I have handled personally. So there was a mortgage case where somebody has taken mortgage and there was insurance. Now, I don't know if you know, there was a case, I can share the details. There was a lady, she was climbing in Russell Cave Mountains, and there was a incident and she died in that. Now, we handled that case. She had a mortgage in her name, and one of the requirements of the mortgage was to have insurance. But insurance has an exception clause that this is an adventure and there's a risk. So in that case, there was no will, and this was not covered by the insurance. So insurance did not take care of the mortgage. So just to be aware, even though insurance is required for all the mortgage, there could be cases where a claim under insurance is not honored for genuine reasons, and then there was an issue, and they had to pay the mortgage amount, the husband. Now, coming to your case about DIFC, of course, Sharia is the main law, but in my experience, so in DIFC will, what happens when it is registered, the probate is issued by the DIFC court, and then there is a communication in Arabic directly from DIFC court to the Dubai court. There is a communication in Arabic directly from the DIFC court to the Dubai court about how the assets are being distributed. And in most of the cases, there are teething issues, but in most of the cases, Dubai court does not apply its own discretion in such cases, and they go by distribution which is done by DIFC court. There are a lot of cases which my office has handled where this is honored. There is a high degree of certainty. As I said earlier, in this part of the world, you cannot be 100% sure. I agree Sharia is the main law, but there is an understanding between DIFC and Dubai court, more so in such matters. So once a probate is issued by the DIFC court, there is a process in place, and actually this you all could see online. This is available on their website, that then there is a process in place. They communicate directly to the Dubai court, and they will ordinarily go by what is directed by the DIFC court.
Can I just...
So if one visits the DIFC website, there are absolute examples of names of probates that have been executed by DIFC, when it was applied, when the execution took place, and when it was issued, including the name of the deceased. So this complete list is displayed on the website.
In the DIFC court, I totally agree. Everything is very clear, and only if a matter goes to litigation, then only in the UAE court the Sharia law applies. I wanted to hear what you say.
Yeah, and just to give an example, that was about how if it goes from DIFC to Dubai court. Now also in our example, in Dubai court, if there is no will, we highly recommend, and this is very practical aspect, that in Dubai court, if it goes to the court in case there is a deceased, quite often they will apply Sharia law. They will not apply Hindu law in my case. And in case you do not think that there will be a dispute among the heirs under Sharia law, so if you think that who would be the heirs under the Sharia law, they should authorize one of the heirs to file before the Sharia court, and they will give the order giving the distribution as per Sharia law. And then if there is no dispute, those heirs can distribute among themselves the way they want. And that is a very practical aspect of dealing with it, even when there is a no will. So what I'm saying is, as a practical matter, rather than going to the court and argue that please do apply Hindu law and it should be as per my law, it is rather better to go and say that please distribute my assets as per Sharia law. But of course, this only works in a case when there is no dispute between the heirs and all are on the same page. And this could And then, of course, once that certification is done, then you could do the way you want, by way of gift or something.
My second question regarding the claim settlement.
Sorry?
My second question, I'm expecting an answer from you.
What is the question again? Sorry.
Can I come in if you don't mind? I know, because I have been wanted to speak on the second question, which is that claims. We are missing a very important point here. Where the product is registered, which jurisdiction is the insurance product from? If it's a policy like Zurich Insurance, it will not be a part of UAE laws. They will pay to the nomination form or the home country law if there is no nomination form. If the local product, if there is a local insurance product someone is taken, that will be part of the UAE process, UAE jurisdiction. So if it's an offshore product, the nomination form is enough, for to make the claim and receive the money.
I just want the number. How many claims, how many expats have registered with you so far? What has been your experience last 3 years? You are encouraging us to take a will, right?
Yep.
To write a will is a necessity today, just like life insurance. So I just want from you, in this 3 years, what has been your experience? How many cases have you dealt with? Any stats, any numbers, do you publish?
We have dealt with a lot of cases. I don't want to consume everyone's time in discussing.
Just a minute, you have a stats. What you do?
Insurance.
There are several such people who are doing it, so him giving you a number is
No,
really going to help you.
No, I know there are many doing it.
Exactly.
If he giving a number,
No, he doesn't, I don't understand now.
Let's go to next question. Can I say one thing, please? Look, if you're talking about life insurance in this country, you're talking with an employer, for example. If you're working for like a company like Microsoft, are you talking about the gratuity, the life insurance there? Or are you talking standalone policies, private companies? Are you talking about that type of life insurance?
So basically, I clarify the question. What she wants to know, how many numbers of cases of
let me
or
tell
how
you
many
one
bills.
thing. How many people,
Either
how
Vivek
many
has
expats
understood-
do take a right to a will? It's only education and awareness. And that's poor in this part of the world. Such a session by IBPC is extremely good because that's education for the people here who are sitting here. If you may ask a question to the people in the room, how many do have a will, rather, have executed it?
Well, my question is, many of us might have multiple wills, such as UAE, India, etc. The question here is, in the event of that, which is considered as the last will?
The $1 million question, yeah. A very good question, yes. You see, when you draft a will, you need to restrict it to the jurisdiction. So if you're making a will for India, you said this will is covering my assets for India. And if you are having assets in another country, you say I'm making a will for this country. But you need to put a clause in the will that this will not contradict the other will. But if you say this is my last will for India, after 6 months you say this is my last will for the UK, then you do another will in Australia, so this is my last will, which people are doing, the will in Australia could technically supersede all wills. So it's very important you have... It depends on the last will that was signed. That's why you have a probate period in some countries, that when a person passes away, you wait 6 months. Because if there is another will, you need to give time for someone to bring the will, approach the court to say, this is the last will. That's why if you've made wills before, and you've updated it and made a new will, you need to destroy all the old wills. Very highly recommended. I hope that answers the question.
Yeah, the last question.
DIFC has already, sorry, just one line. DIFC has already clarified this, that if you have done a will with DIFC and later on you have done any other will in any other country, which does not specify that will is for that country, or it says that all my assets, unintentionally or innocently someone just dropped a local will there, it says all my assets goes to my wife, for example, and the DIFC will has different restrictions. That will cancel DIFC will. So you have to show it to the expert that these are the wills I have, and this is what I additionally need, so that the person can check everything and give you a proper recommendation. Otherwise, it will cancel your existing wills.
My question is to Mr. Mohammed. Now, in Dubai, in freehold properties,
Yeah,
husband owns freehold properties.
100% in his name.
Husband and wife jointly owns freehold properties.
Yes.
Can a joint will be written?
There's no concept of joint wills.
In India there is.
My friend, this is UAE. You have a mirror will, one for husband, one for wife. And if you don't mind me saying, even countries like India, South Africa, even Australia, even the UK, they do have a joint will, but practically it doesn't work. So I don't know why they're doing it, but I think it's more for a cost-effective way. Because don't forget, in countries like India, you have a joint ownership of a property or bank account. By right of survivorship, the wife will get the property or the bank account. So maybe a joint will may work, but technically you should have two wills. Even if I drafted a joint will for you and you went to the court, they will reject it. So you need to have two wills, and the court fees become applicable twice. I wish the court would give a discount if it's to husband and wife. That's why DIFC is 10,000 for single and 15 for mirror. But if you go to Dubai, Abu Dhabi court, the fees are per person. I hope that answered the question.
Thank you. Thank you.